paperwork for the judge. All right, thanks, man. Brian apparently isn't here this morning. Does it show if he's been residing here, or are we might need more paper? Good morning. We got,
I've got Stephen Dworkin. Did you get out?
yeah, I already talked to Al. It's gonna be R1 on accounts.
Okay, beautiful. Appreciate that.
Of course.
Can we get him called for?
Yeah, you just gotta sign in. Keith, can you let me know what page Dworkin is on? It's gonna be mail felony.
Thank you. Appreciate that.
Of course. No problem at all.
Dworkin, D-W-O-R-K.
It's beginning, close to the beginning of the mail felonies. Probably page 19. It won't be. It won't.
8:30.
It won't be exactly 8:30. Probably a few minutes after. Get any lobster then? From what I've heard, though, well, yeah, from what I've heard though, like for those lobster rolls, like the best one, like you gotta find like these little like shacks, like on the side of the road, and like those are the ones exactly. Yeah, yeah, restaurants like yeah. All right, so I gotta call statewide on their 2017 warrant. But when? So
Seen anyone answer as fast as you do.
no problem.
I have Mr. Viola this morning.
It's charged with?
He should be charged with theft, grand theft over 20 or maybe under 20.
VIOLA.
I think that's how you spell it. Let me check one more time. When was he arrested? He surrendered yesterday around 6 p.m.
Let's see.
He didn't make it?
What's that's not how you spell. What's the no,
No, that's
what's
not him.
What's the first name?
Christopher. Oh, shit, so it's gonna be this afternoon.
Well, let's see. Let's see what's going on. Can you get that from?
I think it's VIOLA. Let me check his wife.
I don't even have Christopher Branham with that. He wasn't arrested for that.
The mic's on? Okay, bye.
He's not even in jail?
Let me.
No, I don't think so, because I'm not on the docket for some reason.
Anything.
So it'll be 10, 1070? 1017?
So I'm gonna check to see if she's on the docket.
Oh, no, she's there. She's upstairs. 10 o'clock, 9 o'clock.
She's on the docket. Docket meeting.
I really appreciate that. I'm sorry. Where do I sign in again? Thank you, sir. Great, thank you.
Everyone, I'm Judge Jackie Powell, and this is First Appearance Court. Today, I'll let you know if I've determined probable cause from the police reports I read this morning, and then we will also talk about release conditions. Please note that today is not your trial, it's not an adversarial hearing, and so because of that, I encourage you to speak with your attorneys before speaking on the record. If you are represented by the attorneys from the Public Defender's Office, I do have an attorney in the courtroom with me, Mr. Corey Hill, over at the main jail, I believe Mr. Hector Romero. And these attorneys are available to everyone who's in custody. Those of you who are at the other facilities, they are available to you by phone. If you are represented by private counsel, those attorneys do come to the courtroom. And if your private attorney is not here, you can let me know. We will see how we can facilitate you through that process. Please don't tell me that you have private counsel if you or your family did not contact that private attorney for this arrest. I make phone calls all the time only to be told that they're not representing you. And sometimes folks tell me, oh, they're on permanent retainer. If there's no truth behind that, we'll find out too soon, and then, it'll be a waste of time. So please don't tell me you have private counsel unless some attempt has been made to contact that attorney. You also need to know that in the courtroom with me, I have the attorney from the State Attorney's Office, Mr. Eric Linder, as well as we have representatives from pretrial supervision, confinement status, the clerk of courts, and all these persons are here to help with the hearings this morning. After today, your case will be assigned to a specific division judge, and that means moving forward, any pretrial motions, or if you subsequently go to trial, will be heard by that division judge. Some of you this morning, if you are charged with a misdemeanor or if it's a municipal ordinance violation, and depending on what's going on with you personally, you may be able to resolve your case here at first appearance. But I just need to stress and to let everyone know, you cannot resolve felony matters. You cannot resolve violation of probation. Those normally come with no bond holds. There is nothing that I can do as the first appearance judge in regards to that. You have to see your division judge on those. All right? So with that being said, okay, I have two persons who are signed in, but gentlemen, I have to check to make sure that they're in the room. So I'll do that now because the jail does not bring everyone in all at the same time for security purposes. So, Mr. Romero, on page 19, there's a Stephen Dorkin. Is he in?
He is present, Judge.
All right, and then how about Anthony Benedict on page 23?
And he's here as well.
All right, thank you. So then we can address Mr. Dorkin at this time on page 19. And I presume you're Mr. Schumacher?
Yes, Your Honor. Good
All
morning.
right, good
Police
morning.
Support. Howard Schumacher on behalf of Mr. Dorkin, Your Honor.
Okay. By the
Let's go right to the
podium, Mr.
podium, Stephen.
Dorkin. All right, Mr. Dorkin, you're before the court this morning for 10 counts of grand theft in the first degree, and I find probable cause for these charges.
Your Honor,
Yes.
I've spoken with defense counsel, who's also spoken with the Assistant State Attorney Al Gutman, who's handling this case. Your Honor, we've agreed to an ROR on all counts. Mr. Dworkin has another case, and Mr. Gutman is going to be merging these counts into the other case, so considering he's already out on bond on that, we have no objection to
All
an
right, so there is another case. He's already out on bond on that case?
Yes.
Okay,
And he's appeared at all proceedings, Your Honor, for the last 3 years.
okay. All right, so based on the information from the state, I will ROR Mr. Dworkin on these new charges.
Thank you,
Okay?
Judge.
All right.
Stephen, you'll be released today. Thank you, Your Honor.
You're welcome. All right, on page 23, Anthony Benedict.
Good morning, Your Honor.
Good morning, Mr. Swickle.
Wonderful to see you again.
Same here.
Thank you very much.
right. Have you had any conversations with the state on these charges?
There is a statewide prosecutor who's involved in on the charges, Ms. Hogan. And we have had conversations with her, and I think what happened in this situation, no PC argument, by the way.
Okay.
What happened in this particular case is they had believed that he had somehow fled and was a fugitive. But I can tell the court this, that there's nothing further from the truth. This is grand theft in the second degree, although there are multiple counts. He was living in North Carolina for 9 to 10 years with a wife, children, a job, absolutely living, as a normal human being. There were no indication for him that he had warrants out for himself. He got into a car accident. They brought him to the jail in North Carolina. The judge even there had him post a $5,000 bond. He stayed there, contacted my office. He has a family member who is here today. He's got over 20 individuals living in Broward County. Once he contacted me, I brought him here to surrender. We have his passport. We have absolutely no reason whatsoever to believe that this man would flee the jurisdiction, given all the things that he did in order to make sure that he was here on time, to make sure that he answers to the charges. I even contacted the clerk of court in the computer system when he originally got arrested in Carolina. Nothing on the system. As a matter of fact, until the end of last week, if he had come to Broward County to surrender and found out earlier, there wasn't even a warrant for him to surrender to in the Broward County Jail. As soon as we found out about this, he jumped on a plane, they were aware of it, and got his butt here. These $500,000 bonds are absolutely, in my opinion, with all due respect, absurd. They are tantamount to no bond at all for this individual and a grand theft of the second degree. No matter what the value of these particular thefts are, they are still categorized as second-degree felonies. We are asking for the court to set a reasonable bond in reasonable conditions on each one of those, remembering this man brought himself here from another state on a $5,000 bond for all of these issues. If he wanted to flee, Judge, he would have fled, would not have sent me his passport, would not have done the things that he did in order to bring himself here on these charges.
Do you realize that some of them are first-degree felonies?
Yes,
If
but
they're
the
not all second-degree?
Yes, Judge, I did realize that,
Okay.
but the ones we were looking at, that we were dealing with the same high bonds on, were still second-degree felonies.
Okay. All right.
Your Honor?
Yes.
I'm gonna ask if the court, would put this on recall. I'm trying to reach out to statewide. Until Mr. Spickle said this, I had no idea that this was a statewide case.
Okay.
Considering there's allegations of a total loss of over $1.1 million, I can't make any argument, and I think a prosecutor should be present if possible to make any argument they see.
Mr. Swickle, do you have somewhere else to be this morning?
Yes, I do have an 8:45 in front of Judge Fanistock.
I have a big docket this morning, so I'll give them time to have the statewide prosecutor here.
And, Your Honor, just to let you know, we actually have another statewide case, and the prosecutor in that case texted me.
Yeah.
I'm reaching out to her to see if she knows Ms. Hogan's contact information.
Okay.
Unless, Mr. Spickle, if you have it.
I had the contact information, but to be quite honest with you, it's not in this particular file.
No, that's
Because we had been in
understandable.
contact for 3 weeks, Judge, you should know, trying to get him down here to
All
do
right,
this.
so then
contacted them.
we should have that person here or get some information from that person.
Yes, absolutely. And I'll run over to Judge Fanistock.
Okay, and then we'll call you or, you come back, we'll wait for you.
Okay, you got it, Judge. Thank you very much. I appreciate it.
You're welcome. All right. Vicky Williams,
North Broward, Your Honor, good morning.
good morning. Ms. Williams is before the court this morning on one charge of aggravated assault with a deadly weapon. It's domestic violence. Number 2 is a touch or strike battery, also domestic violence, and I find probable cause. Ma'am, these are 2 first-degree, one is a third-degree felony, and number 2 is a first-degree misdemeanor charge.
She's not there.
All right, I'll hear from the parties. Does Ms. Williams have any priors?
I'm checking into that right now, Judge. Your Honor, I see no history. I'm going to be requesting a $5,000 bond on one, a $1,500 bond on count two, no victim contact.
Judge, I had the opportunity to speak with Ms. Williams this morning in regards to the financial bond set by the state attorney. As far as Ms. Williams is concerned, would the court consider, due to her financial situation, because I'm assuming the court's going to order no contact, which is going to require her now to come up with additional money for a different place to stay. She's asking the court if the court would consider a $2,500 bond on count one. And does count two need a bond since it's a
Yes.
misdemeanor?
Yes.
I'd ask for it to be $100. She can come up with about a total of $250.
All right, I find probable cause, I did read this affidavit, I did see that, Ms. Williams, it looks like she's suffered a self-inflicted wound with a knife that she had. So I will grant the $2,500 bond on one, it'll be a $500 bond on two. No victim contact, that means no phone calls, no text messages, no social media, no third-party contact until that order is lifted by a judge. Do you understand that?
Yes, I do.
Okay. All right, good luck, ma'am. Taisha Dupree?
Hello?
Judge, how are you?
Good morning. All right.
Mr. Dupree is here at Maine.
Ms. Dupree is before the court on two municipal ordinance KPSs. And you did not report to court on September 6th, where the charges are possession of a shopping cart and resisting without violence. All right, I find probable cause. Ms. Dupree, what is it that you want to do today?
I want to resolve it, miss.
Okay. Is it a time served offer?
Yes,
Isn't this, all right.
You have to answer some questions.
Is it really a Fort Lauderdale case, Mr. Plant? It says Fort Lauderdale, but I never know if it's that they're arrested there or. It looks like it is. It says Sunrise Boulevard, Fort Lauderdale.
Yes, Judge.
All right, Mr. Dupree, the city of Fort Lauderdale has what's called a community court. And for persons who are charged with municipal ordinance matters like yours, you are eligible to go to community court, which is held every Wednesday at Fort Lauderdale City Hall. What that does for you, ma'am, is if you're able to participate in the program, at the completion of the program, they will dismiss the charges. What's also good about the program is that if you need housing, if you need any kind of services for food or clothes or anything like that, they have persons there on Wednesdays to be able to facilitate that process. So you have the option this morning, I could ROR you and sign an order transferring your case to community court, or you can resolve the case today if that's what you want to do. The offer is adjudication and time served. Otherwise, you have a $500 bond on each count, you can post your bond. So what do you want to do?
I'll do the community hall.
Okay, so I'll ROR you today. I am going to sign the order to transfer your case to community court, but it is going to be upon you, tomorrow is Wednesday. Tomorrow, you have to go to Fort Lauderdale City Hall. They start at 9 a.m. and you have to go there and present yourself before Judge Barner. If you don't, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Yes, ma'am.
It's 100 North Andrews.
No, then that's gonna be deleted. We'll delete it. Mr. Dupree, come back. We're gonna delete the status for tomorrow. And then I'll sign an order saying that the case is to be transferred to community court. And for her, she needs to be there tomorrow.
Tomorrow morning, okay?
Do you know where Fort Lauderdale City Hall is?
No, ma'am, but I'll find it.
We're gonna give you the address.
Do you have it, Mr. Plant?
100 Andrews, 100 North Andrews. So it's 2 blocks north of Broward Boulevard, on your right side.
Okay.
When you get out of the jail, you just walk, you can walk there.
So you heard that 100 North Andrews Avenue?
Yes,
It's
ma'am.
by the
All right.
McDonald's.
So all you've got to do is show up and tell them that you're there for community court, okay?
You have to go.
Yes, ma'am.
But you have to go. If you don't go, a warrant will be issued for your arrest again.
Okay,
We'll be
ma'am.
back
All
here.
right.
Thank you.
Jamia Humphrey,
North Broward.
all right, Ms. Humphrey, you're before the court because you have 5 misdemeanor cases and one, two, three of them are from 2017. But there's a fourth one that, that CAPIS was issued August 22nd of this year. So I find probable cause, and, on the municipal ordinance matter, you have a $50 bond. On the other cases, the judge, issued no bond holds because you didn't show up for arraignment. So what I'm going to do today, because you do have 5 of them and you have a recent failure to appear, you appear before your division judge tomorrow. And these are driving while licensed suspended charges, so you'll appear before your division judge tomorrow, okay?
Yes, ma'am.
It would be,
So I will not be able to make it to work or anything?
well, no, because you have no bond holds. All
Judge,
right?
in speaking with Ms. Humphrey, that's not something the state is willing to make an offer since they're traffic criminal cases.
Well,
Three separate DWLs.
the problem is the DWLS charges. That's the problem, so, okay? All right, so ma'am, you'll see your division judge tomorrow and maybe, something can be worked out there, okay?
Okay.
All right. Princess Butler, all right, Ms. Butler is before the court. Charge 1 is petty theft, number 2 is criminal mischief, number 3 is violation of misdemeanor probation. All right, and Judge Malika signed that VOP warrant June 11th of this year with a no bond hold. So you'll see Judge Malika tomorrow. I find probable cause, and you have a $100 bond on 1. Walika Thomas. All right, Ms. Thomas is before the court. Charge 1 is resisting officer without violence. Number 2 is trespassing on occupied structure or conveyance, and I find probable cause. Do we know, does Ms. Thomas have priors, and do we know what she wants to do?
See, no, his, well, she has, an older theft and, municipal ordinance, violation involving a pet or animal.
Okay?
Judge, if I may, please, I'm a little confused as to the probable cause affidavit, because the initial stop was for a trespass. The arrest itself was for trespass. The police officer followed her into her own home. How can you be trespassing in your own home? Said once inside the home, the woman again refused to identify herself.
Because she didn't prove that she lived there.
But how did she get into the
Your
house?
Honor?
How did she get into the house then?
Can I speak?
I don't know, I don't know the answer to that question.
Or the cop would have arrested her for
We have,
burglary?
we have people that get evicted all the time, and for all I know,
Your
she
Honor?
might have had a key still.
Ma'am, I'm gonna tell you, I don't know what you're gonna say, but you may wanna speak to your attorney before speaking on the record. I don't know if you're gonna talk about the case or not, but
So all I was gonna say is, I did not refuse to give them my identification. When I went into my home to get my identification, he followed me into my home. I asked him if he can just step back out the door because my children are in my home. I will give him my identification. and he refused to leave my home, which I see no reason for him to come inside my threshold.
All right, yes,
Under the circumstances, I don't have an objection to an ROR.
all right. All right, Laura, Ms. Thomas, and you need to stay in touch with your attorney so that you'll know when you have to come back to court, okay?
Okay, thank you.
April Wright,
Ms. Wright is here present,
Ms. Wright is before the court on a traffic capias, and this was issued October 8th of this year, operating with a suspended driver's license, second offense. I find probable cause.
Judge, I'm going to be asking if the court would consider releasing Ms. Wright ROR. Now, my understanding, Judge, is she got mixed up with her court dates. And my understanding, Judge, she just got employed. She's working at Wendy's. She's waiting, she gets paid every bi-weekly. She's waiting on a check to come in next week, which she believes is going to be approximately $350. She's going to get into a payment plan to try and restore and get a valid driver's license at this time. So she already has a plan set, Judge. She will be coming to court. So I'm asking at this time if the court would consider releasing Ms. Wright ROR.
Just so the court's aware, Ms. Wright was arrested a month ago for two separate cases. One on a pending DUI that she posted a $1,500 bond, and then on a separate capias for DWLS that she posted a $500 bond on.
And that's what led to her confusion, Judge. She actually went to court, I believe, October 10th.
Yeah.
And she has a court date coming up on when was it?
The 25th.
The 25th. So she got her court dates mixed up. If the court's not inclined to give her a straight ROR, then I just ask you to leave it the same. I'm going to be contacting her family.
All right,
And-
I'm gonna leave the bond in place. She has a $100 bond. Janita Mathis,
Judge, she bonded?
okay, thank you. Alexandra Dominique,
No problem, Your Honor.
did we handle her yesterday? All right. So, Ms. Dominique, if she's there, we already handled her case yesterday.
Okay,
All
we
right.
will contact the
All
leader out the dock.
All right, thank you.
Welcome.
Abby Wesby,
She's a medical reset.
Ms. Wesby's a medical reset.
Shiro.
Stephanie Shiro.
No problem.
All right, Ms. Shiro is before the court. Charge 1 is dealing in stolen property. Number 2 is false owner info for pawn items. 3 through 6 are violation of felony probation with no bond holds. And I find probable cause. And I am going to leave the bonds in place on 1 and 2.
Am I allowed to speak, Your Honor?
Yes?
Okay, so I've been in a drug program for the past 3 months, 90 days that Coleman put me in. These charges were obtained before that. Yes, it was while I was on probation, but I also went to my probation officer and told him I had a problem with methamphetamine. They put me in a drug program. I've been doing amazing in this drug program. I've been working with animals, like my program manager, my boss, everybody's gonna come to court for me tomorrow. And these charges occurred before I've been in this program for the last 90 days of my life. The things that I've done are phenomenal. I went to a Dolphins game. Never thought any of these things were possible in my life. I'm actually clean and today and I'm happy and I'm sorry that I did these things, but I was also on methamphetamine. You know, I've been clean for 90 days now.
Okay,
I mean, I'm just letting you know.
okay. Well, you'll see your division judge tomorrow on these, okay?
Thank you, ma'am.
All right, Lorraine DeMarco,
She was deleted from the docket also, Your Honor. Her confinement
she's
status.
not from magistrate. All right, thank you. All right,
Okay.
Samantha Sokol. All right, Ms. Sokol is before the court. Charge 1 is petty theft, and number 2 is felony violation of probation, which has a no bond hold. And you will see your division judge tomorrow. I find probable cause, and you have a $100 bond. on one, okay?
Thank you.
Talvanisha Thompson,
She's present here at Angel.
all right, Ms. Thompson is before the court on a grand theft charge, and I find probable cause.
Judge, at this time, nothing to add. I'm gonna be contacting Ms. Thompson's family post bond.
All right, Ms. Thompson has a $1,000 bond and an order not to return to CVS. Asia Fillmore,
She's approaching. Come on up, Ms. Fillmore.
Ms. Fillmore is before the court on a grand theft charge, and I find probable cause.
Judge, nothing to add. I'm gonna be contacting Ms. Fillmore's mother to post her bond.
All right, $1,000 bond and no return to CVS in Lauderhill. Andrea Lara Quinte,
North Broward.
She's a medical research on.
all right, Ms. Lara Quinte is a medical reset. Jacqueline Nebelloni,
No problem.
all right, Ms. Nebelloni is before the court on burglary, unoccupied dwelling, unarmed, and I find probable cause. I know Ms. Nebelloni has had some prior trespassing charges, and I don't know what else.
Judge, I know why the state's looking. I know I had the opportunity to speak with Ms. Nebeloni this morning. A financial bond will not work due to her situation and her circumstances. At this time, she was going to be asking for pretrial release in lieu of a monetary bond.
Okay,
Your Honor, I'm just checking to see if there's been failures to appear. Your Honor, so far, I count since October of last year, 5 arrests that were all on capiases for failures to appear. One of them was on a violation of pretrial. Ms. Nebuloni has just shown no willingness to willfully appear in court. In light of that, and because this was someone's home, Your Honor, I'm going to be requesting a $10,000 bond, no return, no victim contact.
all right, I am going to impose a $5,000 bond. No
Can I
victim.
please get,
Can
Your
you-
Honor,
Yes, ma'am.
I have changed my life around, and I am willing to be on pretrial release under ankle monitor. I have a place of residence.
All right, Ms. Nebeloni, I'm going to deny that this morning. You have appeared before me several times this year, and we've also heard this morning that you've previously violated pretrial supervision, okay? All right, y- okay,
State.
Hello, residence.
we're finished with you, ma'am.
So what is gonna happen?
You have a $5,000 bond.
I can't.
Ma'am, we are finished, okay? Who are they asking for, Duncan?
Yes, please.
All right, David Duncan. All right, Mr. Duncan is before the court for a trespassing charge, and I find probable cause. Have you been able to speak with him?
Ma'am?
Yes, sir. Mr. Duncan, what do you want to do today, sir?
Go home.
All right, what do we know about Mr. Duncan?
This would be his 6 the rest this year. This
Is
last
it
one-
always at the Broward General Hospital? Because I think that's where this one is from.
No.
Okay.
Not all of them. The last one was at 640 North State Road 7.
All right. What happened? All right, Mr. Duncan, what's going on with you today?
Chest pains.
You're having chest pains?
Yes, ma'am.
All right, we're gonna leave the $100 bond in place at this time, okay?
Judge, I'd ask that if he has not been checked out already, that he be taken to medical.
Sure, I'll see. If you need me to sign an order, let's do that.
It's you.
All right?
All right, come on, Duncan.
With that,
And Judge, I'm sorry to interrupt again. I do see that the Spanish interpreter is here for 2 people.
Who needs a Spanish interpreter?
Page 13. First one is Michael Cabrera Rivero, the top of page 13. And the other one is on page 16, under the name of Eduardo Dominguez.
Corey, that last one, is that Sauce? His last name is Saucedo? Yeah, thanks.
Move that way.
All right,
Move it that way.
where is Michael Cabrera Rivero?
he's here at Main Judge approaching. He's on page, I believe, 13 of the court's docket.
All right. All right, Mr. Rivero is before the court on one charge of DUI, alcohol or drugs.
Señor Rivero comparece hoy, tiene una acusación de DUI, es conducir bajo los efectos de bebidas alcohólicas o de drogas.
And I find probable cause.
La señoría decide que existe motivo fundado.
Chair, I'm going to be asking if the state can verify. This is my understanding. This is his first contact with the criminal justice system. I'm going to be asking for ROI.
De parte de la defensa queremos que si es posible confirmar con el Estado que es la primera vez que el señor tiene contacto con el sistema penal. Vamos a pedir que si es lo correcto, que el señor pueda quedar en libertad bajo su propia palabra.
Now, Judge, he does work here. He works at Comcast. He's been living with his wife in the same location apartment in Tamarack for several years. So, Judge, he has strong ties to community. If the court's not inclined for straight ROR, then I ask for a phone order.
Y también queríamos dejarle saber a la Corte que el señor trabaja localmente, trabaja en Comcast, vive con su esposa ya hace varios años en Tamarack, en un departamento, así que tiene vínculos concretos con la comunidad. Si la señoría no quiere permitirle libertad bajo propia palabra, podríamos pedir que firme una orden para que tenga acceso a su teléfono.
Well, I'm gonna tell you that based on these allegations, it also involved, there's damage that seems to be consistent with a crash. He was asleep behind the wheel. They made several attempts to wake him up. I'm not going to ROR him based on these allegations.
De acuerdo a las alegaciones que estoy leyendo aquí, existen daños y parece que tiene que ver con un choque. El señor estaba dormido en el volante y tuvieron que intentar varias veces para lograr despertarlo. Así que basado en esas alegaciones no voy a permitir que quede en libertad bajo su propia palabra.
Your Honor, he just has traffic matters in his past.
Okay.
De parte del Estado, solo han encontrado algún tipo de multa de tránsito anteriormente.
Based on the reasons you already stated, I'd be requesting pretrial as opposed to an straight ROR.
Y de acuerdo a lo que dijo la señoría anteriormente, el Estado también pide que quede en libertad bajo supervisión en el programa de libertad previo a juicio.
Right, Mr. Romero, so he has the option, does he want to post a $500 bond or be on pretrial?
We're gonna be asking for a phone order then, Judge.
All right,
Él tiene puede decidir si quiere pagar $500 de fianza o quedar en libertad bajo libertad condicional. Va a pedir la orden para tener acceso al teléfono.
all right, Eduardo Dominguez Salcedo,
See, they don't do afternoon first appearances. Here.
He's approaching, Judge.
all right, Mr. Salcedo, you're before the court for an ad charge. This is now charge number 6.
Señor Salcedo, vuelve a comparecer porque le han agregado un cargo, es cargo número 6.
It is an immigration hold.
Esto se llama detención por parte de inmigración.
I find probable cause,
La señoría decide que existe motivo fundado.
and you will have to appear before an immigration judge on this charge.
Debe comparecer con un juez de inmigración en lo que tiene que ver con este cargo.
And it does have a no bond hold.
Y por este cargo no tiene posibilidad de conseguir fianza.
All right, is there anyone else who needs the Spanish interpreter?
¿Alguien más que necesite ayuda del intérprete? Por favor, avisar a la persona que está a cargo.
Not here at Main, Judge.
All right, thank you very much.
Thank you, Ana. Good to see you.
Good to see you. All right, Mr. Plant, on page, I don't know what that is, Peter Gilboy?
He's approaching, Judge. He's here at Main.
All right. Well, no, I have it, I just can't read your handwriting to see what page it is. All right. Mr. Gilboy is before the court. Charge 1 is a municipal ordinance violation. Number 2, he has a parole violation as well. The parole violation, of course, is a no bond hold, so we'll have to appear before Department of Corrections. I find probable cause, and I don't know if this municipal ordinance is part of this parole violation, so I am going to leave that bond in place at $25. All right?
Good luck, sir.
And then Kevin Furlong?
He's on medical law now, Your Honor.
Now Mr. Furlong is medical law. All right, Mr. Shade, thank you. Did I call you Mr. Shade? I'm sorry, Mr. Plant. You know, you guys are like
It's interchangeable.
interchangeable, right? All right, where is Henry Christian? Is he at the main jail? Mr. Romero, can you help us out?
Sorry, Judge.
Is Henry Christian
he's
at the
approaching.
man? Are you, is a PD representing him, and do you need time to, because he's on page 20?
I already spoke to him, Judge.
Oh, okay. All right, good morning.
Good morning, Judge. Jessica Nordland on behalf of statewide prosecution. This defendant was picked up on an arrest warrant on one of our cases, so a previous judge already found probable cause. The bond was set with multiple special conditions, so I would just ask this court to leave everything in place.
All right, so just so that it's on the record, Mr. Christian, you are before the court today. There is 3 charges of keeping house for gambling. 4 and 5 are racketeering violation. Number 6 is money laundering. 7 through 15 are bookmaking charges. Number 16 is assistance setting up or conducting lottery. 17 through 28 are bookmaking charges. And I read through all this 154 pages of affidavit, and I find probable cause for these charges.
Judge, I understand the state's request, but the total bond in this case is $422,000. Now, he was extradited from New York. I believe he's been in custody since June 18th. From what he advised me at this time, before he was picked up, he wasn't working. He basically lives with his mother in an apartment in the city of New York. My understanding is his mother is retired on a fixed income, receives Social Security. To my knowledge, from what Mr. Christian advised me, he has no sort of property, no sort of assets. He has no money in the bank. My understanding, he has prior contact with the criminal justice system, but I believe it's dated. I believe it's from the 90s in New York, so nothing recent. Judge, from what he advised me, he nor his family are in a position to post a $422,000 bond. I'm asking at this time, Judge, if the court can take into consideration his financial situation and consider a reduction in bond.
Well, I stopped counting how much money is involved here.
Judge, there's, hundreds of thousands of dollars
Right.
that went back and forth throughout this entire case, so I would be objecting to any change in the bond at this point. If the defendant wants to file a motion later, I'd be more than happy to consider it, and we can address it in front of the trial judge at that point and possibly have a hearing, but at this point, I'd be objecting to any modifications
Right,
of the
I am
bond.
going to leave the bonds in place and all the special conditions that came along with the warrant that was signed. All right? I'm sorry, all special conditions will apply.
Thank you, Judge.
Mr. Plant, on one of the, I don't remember which one now, there's already an appointment. That's it, I don't remember which one. Is it one of these?
Yes. It's Orlo.
I think so, okay. All right, Lorenzo Sanchez. Mr. Sanchez, you're before the court. Yeah?
Proceeding pro se, Judge.
All right.
I'd like to review the probable cause affidavit to defend myself, ma'am.
Well,
Please.
here's the problem. You are, this is on a warrant from out of state. So I don't have that available to me. You'll have to go to South Carolina to deal with that. South Carolina issues a warrant and says that they want to hold you no bond to bring you back. So that's what I'm here to tell you today. Once you get
All
to
right, thank
South
you.
Carolina, you'll have to deal with that.
All right.
All right? Charles Fry.
North Broward, Judge.
Good morning, Mr. Fry. You are before the court. Charge 1 is burglary with assault or battery. 2 and 3 are criminal mischief. Public phone cables, fixtures, equipment.
Yes, the house belongs to me and my wife.
All right.
Uh,
Sir, today is not your trial. That's not what the probable cause affidavit says. So whatever information you have, you need to give that to your attorney. But for today's purposes, I find probable cause. Does Mr. Fry have any priors?
Arrest in 2013 for aggravated abuse of a child. The charge was dropped. I don't see anything else. I am going to be seeking a finding of proof evident or presumption great and a no bond hold. My concern, first, just the allegation of how he entered the home. He allegedly kicked in the door, which would seem to go against his claim that it's his home, considering he apparently didn't have a key to get in and forcefully entered
I
the
had a
home.
key. I had a key. I just,
All right,
should they let,
Mr. Fry, I'm gonna tell you again that if you want to talk about your case, speak to your attorney.
okay.
Then once
Right.
entering, chasing one victim out of the home. There were 2 witnesses to this matter. They both gave sworn statements. He's personally known to one of the victims, as she is his daughter.
Judge, I had the opportunity to speak with Mr. Fry today. Due to the situation and the lack of history with Mr. Fry in our criminal justice system. I understand this is a PBL, I understand this is very serious. But as you just heard from the state, this is kind of a family dispute. The allegation is that this gentleman went after his daughter's boyfriend. So again, we don't know the specific set of facts as to what the boyfriend may have done to prompted that. I'm not saying that gave him a right to do so, but this does feel like a family squabble between a father and daughter. As a result, would the court consider, due to his lack of history, placing him on pretrial release? Even though the court may find proof evident presumption great, but based upon the information I provided, we would be asking for pretrial release.
All right, this is a first-degree felony charge, and, sir, I have to go by the probable cause affidavit to make my determinations today, and these allegations does say that the residence is in her grandfather's name, one of the alleged victims, and that she's the sole inhabitant of the home, and that you went to the house, kicked the door in, pushed her out of the way, grabbed the other person, and I don't know if it is a family squabble, but these allegations do amount to the charge of burglary with assault or battery. And so at this time, I make a probable cause finding, and you were identified by both of them. Defendant threw items causing a hole in the wall and a broken mirror and a TV stand. So I am going to make a preliminary finding of proof evident presumption great, and you'll be held no bond until you are able to appear before your division judge for a bond hearing. Okay, and then the other bonds that are in place on 2 and 3 will remain. No victim contact, sir. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
Okay. All right. Then next we have Leon Miles. Mr. Miles is before the court. Charge 1 is battery, second or subsequent offense. It's a domestic violence. And then number 2 is an out-of-county civil hold, and that is out of Hillsborough County. That does have $1,000 that's attached there. So if you're able to post that $1,000 on that charge, you'll be able to be out. And I find probable cause. This incident is from September 4th of this year.
Just pulling up his history if Mr. Romero wants to proceed.
Okay.
Yeah, I can in this matter. In speaking with Mr. Miles, I understand, as the court pointed out, this happened about maybe a month or almost 2 months ago, a month and a half. My understanding since then, the alleged victim, his girlfriend, I believe is trying to reach out to the state attorney's office to do a waiver of prosecution. Now, my understanding, Judge, in speaking to Mr. Miles, he's working, just got a job, about 4 months working at Five Guys. He just got promoted to assistant manager, where he's now making $13 an hour. He's been living in our community since 2015. He's 30 years old. Actually, his girlfriend's going to be the one that he advised me that's going to be posting his bond. And my understanding is she works at SunPass, but with all the bills, I believe their financial resources are limited now. I told them as far as count 2, there's nothing this court could do. It's not for magistrate, but in reference to count 1, Judge, I'm going to be asking the court to consider a $2,000 bond on his behalf.
Your Honor, as far as his history, I see 2012, he pled a battery out to disorderly conduct. He was arrested in Leon County in 2011 for failure to appear in a battery. Another failure to appear in 2010, another one in 2010. He had a battery in '09 in Leon County. Excuse me. And that was the basis for the up file from what the officer presented from misdemeanor to felony offense. State would be, I'm fine with a $2,000 bond, Your Honor.
So it's a $2,000 bond on one, $1,000 bond on, well, the $1,000 is a purge amount on two. No victim contact, sir, no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
All right. All right, Michael Johnson. All right, Mr. Johnson is before the court on two charges of aggravated battery with a deadly weapon. It's domestic violence. And number 3 is a traffic infraction that's not for magistrate, and I find probable cause. All right, whoever wishes to go first.
Just, Your Honor, excuse me. State would be requesting a $10,000 bond on count 1, $5,000 bond on count 2, no victim contact. 2016, Mr. Johnson pled a felony down to misdemeanor battery against a different woman. 2010, trafficking in oxycodone, 18 months state prison. 07, burglary structure, 3 counts of burglary, conveyance, and grand theft. 05, he was convicted of battery against a law enforcement officer resisting without violence. He was also convicted of 2 counts of domestic violence battery against 2 different alleged victims. Grand theft in the late 90s, but those are the relevant priors, Judge.
Okay.
Judge, I had the opportunity to speak with Mr. Johnson this morning. Before I discuss his matters, I know the court found probable cause, but when reading the probable cause affidavit, the reason it's an aggravated battery is due to a hammer, except the 2 facts in the police report are the following. The witness, the person in the drive-thru, stated she observed the defendant hit the victim in the face with an open hand. And then in the second to last paragraph, the police officers are talking to the defendant, and talking to the victim, and the victim did not say that the defendant hit her with a hammer. So I don't see anything in the probable cause affidavit. They found a hammer on the ground. That's the only thing that they actually mention of a hammer. The cop mentions that some injuries that were on the lady, he said marks on her arms are consistent with the size of a hammerhead. That's the only allegation for an aggravated battery. I would say that is not probable cause, just looking at an injury. That could have came from anything. Just assuming it
Well, I
comes from a
disagree
hammer.
with you. There's a phone call from a witness that says, I see this person hitting the person with a hammer. Then there are hammer marks, marks on the victim's arm consistent with hammer marks. I find probable cause, and let's talk about bond.
Judge, Mr. Johnson indicated he receives $771 a month in SSI benefits. That is his only source of income. A financial bond on this matter, in regards to Mr. Johnson, would not be reasonable for him to post due to his financial situation. As you can see, he is disabled. So at this time, Mr. Johnson is asking if the court would consider a pretrial release.
All right, I am going to deny that. He will have a $10,000 bond on 1, a $5,000 bond on 2. No victim contact, and sir, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
All right.
I got some money in the bank. How do I get out?
What was that?
Yes, the money.
If I got the money in the bank to get out, how do I get
Sir,
out?
you have a total of $15,000 bond. You can speak with your attorney about that, okay? All right. Mr. Swickler, are you ready with your case?
Is that all?
Yes, sir. All right.
Logan on behalf of the Office of Statewide Prosecution. Judge, I apologize. I didn't realize that this was on this morning. I know he surrendered last night, but.
No problem. I'm glad you're available and thank you for coming down. Have you and Mr. Swickler have an opportunity to speak?
Well, we
Spoken on the phone.
we spoke a couple of weeks ago, and
Okay.
Judge, the defendant has been on the lam for the last 10 years. The charges in this case are multiple counts of grand theft, first degree and second degree. The total amount of loss was $2.5 million. There are multiple victims still around. My detective would have been here had we known that it was going to be on calendar this morning. I did speak with him this morning prior to coming to court. He's been reaching out to all of the victims to make sure they're still available, considering the length of time that's passed. When the defendant, before the defendant left town, the defendant had promised many of these victims that he was going to meet with them and then pay them the money that he owed them. This case is based upon fraudulent bridge loans that the defendant was basically offering investment opportunities for the victims in this case. Instead, he took all of the money and used it for his own benefit. He then fled. Approximately 10 years ago, and I'm not sure of the exact time frame, there was a border crossing of the defendant heading to Canada. That was the last time we knew about his whereabouts until over a year ago. The defendant had an attorney, and I don't know if it was this attorney, but an attorney reached out to Agent Roadruck from FDLE, who's the investigator on this case. They reached out and said that he wanted to surrender himself. And Agent Roadruck said, "That's great. I'll meet you at the jail." That was over a year ago. No, and then Agent Roadruck didn't hear anything since. They have continuously reached out to try and locate this defendant, and it wasn't until just recently when the defendant was arrested because he had been involved in an accident in North Carolina that we were able to finally take him into custody. At that point, the judge there bonded him out because the defendant didn't waive extradition, and now here he is. He did surrender himself. However, that was after 10 years, $2.5 million stolen from these victims, at least the victims that we've spoken to. There were more that we didn't speak to. And Judge Williams, at the time when he signed the warrant, he set a $5 million bond. And I would ask that Your Honor keep that bond intact. I think it's appropriate considering the defendant is a flight risk, and we know that from his own conduct. And I would also ask that the court have a nebia requirement as well.
Is that all? Sure.
You heard some of my arguments before, but I know counsel wasn't here, so I certainly want to give her the benefit of that. There is absolutely no information that he was, quote, on the lam. I'd like to hear from the state what efforts and who they've contacted. I don't know anything about this attorney that they're saying that he contacted and said that he would turn himself in. But he's been living in the exact same place for 9 years, taking care of a wife, 9 to 10 years, taking care of his wife, taking care of his children, taking care of his brother-in-law, who's a quadriplegic. He found out about this through a car accident, posted a $5,000 bond. If he wanted to leave, he would have taken off. The border crossing just means he went out of the country for a few days. That doesn't mean he was on the lam. If he's on the lam, as they say, why would he go cross the border and then bring himself back? He has a relative.
But you do realize that this is all after he knew that there is this case that's pending against him. All of these things happen after that. Whether it's on vacation or whatever it is that you want to say, it all happened after this.
We don't know that.
Well, the prosecutor is telling me that there was another attorney that was involved, that you weren't the attorney, that they had that conversation, so.
Who was the attorney? What conversation was happening? How do we know that he was dealing with that issue? You have to actually, you can't just come in and say, well, somebody spoke to an attorney a year ago, and therefore he was on the land.
But then
Judge-
the same holds true, that you can't just come in and say he wasn't on the land.
If
Yeah,
I
but
can
it's
add,
their
Your Honor.
burden- Excuse me, it's their burden to prove
I
that he
understand.
was somehow a fugitive. He has a relative in law enforcement.
All right, this is first appearance, and so I expect that you both are going to have evidentiary hearings before your division judge, which is not the purpose of this hearing this morning. So I am going to leave the bonds in place at this time, and I am going to also add the Nebbia requirement if Mr. Benedict is to post his bond. I am going to ask you to prepare that order because I was looking through to see if it was already there, and I didn't see that order, so,
So just for purposes of the record.
yes.
Based on my information, there's absolutely no way that he would be able to post a $5 million bond, especially in light of the value of what the allegations are, to double the bond on what it is that he's even alleged to have taken. We believe is tantamount to no bond at all. Given his
Noted.
financial circumstances, it's just not something that he would be able to post even if he desired it, and therefore it's just like giving him a no bond hold for purposes of record.
So noted. No victim contact, and that means no phone, all these victims, no phone calls, no text messages, no social media, no third-party contact. And State, please prepare that order on the media requirement. Thank you.
Thank you, Your Honor.
You're welcome. Joel Garcia Zelaya.
Please approach him here, Judge.
Mr. Garcia Zelaya is before the court. Charge 1 is a violation of injunction protection, domestic. And number 2 is a violation of felony probation. That has a no bond hold. All right, I find probable cause.
Judge, I'm going to be asking for a $2,000 bond on count 1. My understanding is he works in landscaping. He lives in Sunrise where he's renting an apartment with a roommate. He's been there for 1 year, making about $700 per month. At most, maybe putting all his financial resources together, if he's able to somehow, when he goes to court tomorrow on his probation case, get that some way modified as far as from the no bond hold. The only thing he's going to be able to afford is $2,000, so that's why we're asking that amount, Judge.
Your Honor, the state is going to be requesting a $7,500 bond on count 1, pretrial release with a GPS monitor. First, I think the court should be aware the victim in this case is the same as the victim in the 2016 aggravated battery with a deadly weapon that he's on probation for. He was sentenced to 6 years probation as a habitual offender by Judge Cohen. This would be his 3rd violation of that probation. Also noting that in 2011, he was convicted of domestic violence battery by strangulation and misdemeanor battery, and that was against a different alleged victim.
All right, $5,000 bond on 1 with a level 2 pretrial and no victim contact. And sir, no victim contact is in place until a judge lifts that order. An injunction is in place until a judge revokes that injunction. All right, so no victim contact and level 2 pretrial. Mr. Nanda is still on medical loan.
Yes, sir.
Todrick McNair,
How you doing today, Judge?
North Broward.
thank you. Good morning, Mr. McNair. You are before the court on an ad charge this morning for a misdemeanor capias.
Yeah, I forgot all about that case. I left my house and went somewhere place else.
All right, that capias was issued August 14th, Mr. McNair is in custody on other matters?
One moment, Judge.
He's being released to probation? All right. All right, Mr. McNair, I can ROR you because I've been told that you were in custody at the time that this capias was issued, or you can resolve the case if you so desire.
State's offer be a withhold court cost.
I resolve.
And the state's offer to resolve is a withhold adjudication and court cost.
Yes, ma'am.
All right, you wish to accept that?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And sir, do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves a withhold adjudication and court costs. Good luck.
All right, thank you.
You're welcome. Adam Leonard.
Who's approaching? Judge, Mr. Leonard is approaching.
Okay. Mr. Leonard has a capias from almost a year ago on a disorderly conduct matter. What does Mr. Leonard wish to resolve his case today?
He does, Judge.
Yes.
All right, Mr. Leonard, I'll sentence you to time served. Do you wish to accept that?
Yes, ma'am.
All right, Mr. Leonard, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you understand this offer that I've extended to you this morning?
Yes, I do, Judge.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
I'm in detox, and I wanted to ask you, Judge, is there any way that you could help me get into the Salvation Army Adult Rehabilitation Center?
I don't, I know, I can't sentence you there, but the city of Fort Lauderdale, you can go to their community court tomorrow at the city hall. And even though you may not have a case pending there, and I can't send this case there because it's from, the arrest is from West Park, but you can still go to the community court to get services. The only service they won't be able to give you because it's not a city of Fort Lauderdale case is housing. But they can help you with everything else, and maybe they can help you to get into the Salvation Army.
Well, it's an in-house program.
Right, but you would have to show up at the community court at City Hall and tell them the services that you're looking for, and they can help you with that.
Yes.
All right. So let's go back to the question. Are you under the influence of drugs or alcohol today, as we're speaking?
No.
All right. And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
That's right.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I am a U.S. citizen.
All right. What plea do you wish to enter at this time? Guilty or no contest?
Yes.
Which one?
Guilty or no contest, sir?
Oh, what do you mean?
What is going to be your plea, sir? Is it going to be guilty or no
contest?
All right. I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. And like I said, tomorrow they have community court at the city of Fort Lauderdale. If you show up there, they can help you with services, okay?
Thank you very much.
All right, good luck, sir. George Montgomery.
He's approaching, Judge, you see what I mean?
All right, Mr. Montgomery, you're before the court. It's on a panhandling charge, and I find probable cause.
Judge, Mr. Montgomery wishes to resolve this matter today.
All right.
I'm served.
All right, Mr. Montgomery, I'll sentence you to time served. Do you wish to accept that?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, sir. No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Montgomery? Guilty or
No
no
contest.
contest? I accept your no
contest.
contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and time served. Good luck. Omar Payret.
He's approaching, Judge, you see what I mean?
All right, Mr. Payret is before the court on a trespassing charge, and I find probable cause.
Judge, in speaking to Mr. Payred earlier today, he wishes to resolve this matter.
Your Honor, Mr. Payret's been through this division multiple times. The offer would be adjudication, 5 days, no return.
When was the most recent time that he was
Most
here?
recent was August 19th. And that was on a capias for a trespass. It looks like he got 5 days.
All right, Mr. Parrott, if you resolve your case today, it is going to include 5 days in the Broward County Jail.
You wish to accept this one? Yes. He wishes to accept this case offer.
All right, Mr. Parrott, I'm gonna tell you, because I see this all the time, that the officers say that they give you a verbal warning, and then if you keep going back, you're gonna keep coming before me or maybe before another judge, and it's not gonna be 5 days. Do you understand that?
Yes.
All right, this is a first-degree misdemeanor. It does carry a maximum sentence of a year in the county jail. Do you understand that?
Yes.
All right. So for today, you resolve your case, it'll be 5 days in the Broward County Jail. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication 5 days in the Broward County Jail with credit for any time served. All right, Irvin March.
North Broward, I believe.
Okay, I'm gonna have to find him, Your Honor, because it says main jail on here.
I'm sorry. Sergeant March is here. My mistake.
They're just playing with you this morning, Deputy.
I apologize.
All right, Mr. March, you're before the court this morning for a trespassing charge, and I find probable cause.
Judge, I'm going to be asking the court to consider releasing Mr. March, ROR, I did speak to him earlier today. He has a very hard time of hearing. He's 73 years old, Judge. He lives here locally in Fort Lauderdale. He's been residing in the same place for 4 years. From what he advised me, there's no one that's going to be able to post his bond. I told him one of the conditions, if the court were to release you ROR or under supervision, is he's not supposed to go back at the area that he was arrested. He did advise me he understood that, Judge. I'm going to be asking the court, considering $25 he cannot make, I'm asking the court to consider releasing him ROR or on the alternative pretrial release.
All right, this is also a Fort Lauderdale case, and even though it's a state charge, he could go to community court. Does, you want to talk to him about that?
I would. Judge, I believe Mr. March would be interested in participating in a community court in the city of Fort Lauderdale, Judge.
All right, that's tomorrow, and I'll ROR him and sign that order to transfer to community court.
Your Honor?
But yes.
I just want to check to make sure that there's nothing in his past that would be an
Okay,
issue.
okay.
Judge, can you give me the address so I can write it down for Mr. March?
I believe it's 100 North Andrews Avenue.
Thank you.
Looks okay to me.
Okay. All right, Mr. Romero, I know that you said he can't hear very well, so if you'll just let him know, it's tomorrow, and he has to show up there.
To show up to community court. It's at the city of Fort Lauderdale Government Center, and I'm writing down the address for you, okay, sir? Okay. Judge, what time?
9 a.m., I believe they start.
Yes, sir.
Your Honor?
Yes.
Just ask again if you could remind Mr. March not to go back to this location. He was here 2 weeks ago at the same location.
All right, and he cannot go back to, what is the location?
It's a Ivory store.
All right,
What store, Mr. Lender?
it's called Ivory Store.
Okay.
All right.
Thank you, Judge.
Okay. All right, David Burbick.
Bonded, Judge, I'm sorry.
All right. And so Andrew Fern is the next person. All right, Mr. Fern, you are before the court. Charge 1 is DUI, alcohol, or drugs. Number 2, driving while license suspended. Number 3, 4, and 5 are traffic infractions that are not for magistrate, and I find probable cause.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Fern's friends and family to post his monetary bond.
All right, I'll leave the standard bonds in place. Bruce Edelstein.
Judge, Mr. Adelstein is here at Maine. He's he declined the service of public defender. He will be hiring his own attorney.
All right, sir, you are before the court. Charge 1 is DUI, alcohol, or drugs. And number 2 is DUI with damage to property or person of another. And I find probable cause. Mr. Edelstein, you understand that at this hearing you are entitled to counsel? Do you understand that, sir?
Yes, ma'am.
And
Yes.
so you are denying the services of the public defender's office?
Yes, ma'am.
All
I
right.
am my own attorney.
Okay, all right, you have a total bond of $1,500, sir, okay?
Okay.
Yes, yes,
No, I'm sorry, talking to Mr. Ndash.
okay. And while you're out on bond, no alcohol or intoxicants, do you understand that?
Yes, ma'am.
All right, good luck, sir.
Thank you.
All right, Manuel Lavernia,
Mr. Lavernia, come on up, please. Please approach the judge.
All right, Mr. Lavernia, you are before the court. Charge 1 is DUI, alcohol or drugs. Number 2 is DUI with a breath level greater than .15. Number 3 is leaving the scene of a crash involving damage to property. I find probable cause for these charges.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Lavernia's family to post his monetary bond.
Does Mr. Lavernia have any priors?
One moment, Judge. From what I can tell, just a lot of traffic tickets.
All right, based on the allegations, Mr. Lavernia, he did blow a .250 and .259. And then there are allegations that, he fled the scene, of the accident on foot, made no attempt to render aid or exchange information with the victim driver. I am going to impose a $1,000 bond on charge number 3 as well. Okay? So he'll have a total of $2,500 involved. San Juan Bennett.
I believe in regular court, Judge, room number 10170.
Okay. All right, Mr. Bennett is in court. Tony Lawson.
No problem.
Mr. Lawson is before the court. This is an ad charge, sir, for possessing, receiving, retaining stolen credit or debit card. It is a third-degree felony, and I find probable cause, and you have a $1,000 bond on that charge. All right, Canaris Hall.
Conti, Your Honor. Your Honor, he's in courtroom 5155 today.
All right, thank you. Mr. Hall is in court.
Yes, ma'am.
LaMoncha Quill Mathis.
Sure, main judge.
All right, Mr. Mathis is before the court on one charge of burglary, unoccupied structure unarmed. Number 2, grand theft, $1,000 or more. Number 3, violation of felony probation. Number 4, burglary, unoccupied conveyance unarmed. All right,
And Your Honor?
yes.
While it doesn't specifically list the amount in this probable cause affidavit, I would ask the court to take judicial notice of his co-arrestee's probable cause affidavit, Abby Wesby. She was reset this morning, but it does state in her probable cause affidavit that the 6 bikes that were found in the van have an approximate value of $12,000.
All right, I did see that, and I believe there's another co-defendant.
Yeah,
But
he's
there's
next.
another, okay. All right, so I find probable cause for these charges, and, Mr. Mathis will see his division judge tomorrow for the VOP.
Your Honor, in lieu of the VOP, state would be requesting a $2,500 bond, no return on count 1.
And Judge, my only question is, I know in speaking to Mr. Mathis, I did advise him there's 2 burglaries specifically on count 4. We just want to know when the date of an incident on that offense.
All right, I'm looking back, the second burglary,
Count 4?
no, I know. I don't think that we have information for a second burglary.
There's a second, Your Honor, there's a second.
Oh, no,
booking sheet
never
or
mind,
something.
I take it back.
Eh,
There
eh.
is a October 14th, incident date. This incident was at the Pinch a Penny, and then the other incident was at Downtown Bike Shop. Okay?
And Your Honor, I didn't realize there were 2 burglaries. I'd be requesting $2,500 on each.
Yes. All right. So, I am going to grant, the state's request, $2,500 on charge 1, and $2,500 on 4. And no return to either of these locations. Perry Turner. All right, Mr. Turner is before the court. I think on this one, they messed up the, no, never mind. They just wrote the report differently. All right, Mr. Turner is before the court. Charge 1 is burglary, unoccupied structure, unarmed. Number 2 is grand theft. Number 3 is operating without a valid driver's license. Number 4, again, is a burglary, unoccupied conveyance, unarmed. And I find probable cause.
Your Honor, again, just making the same request as far as the amount of the bikes.
Okay.
Secondly, state would be requesting $2,500 on each burglary. Mr. Turner is currently out on bond from a 2018 possession of cocaine with intent to sell or distribute. He also has priors for uttering a forged instrument, grand theft. He has some other priors, drug-related, but the ones I mentioned are the most relevant and recent.
Okay.
Judge, I'm going to be asking you at this time to consider releasing Mr. Turner. He's asked me to ask the court an ROR or in the alternative on pretrial release. Now, he's been here his whole life. He's 38 years old. He's currently working. He's been working for the same landscaping company for the past 6 months. He gets paid daily whenever there's work and the weather permits, anywhere from 100 to 125. Now, he lives in Fort Lauderdale with his aunt. My understanding, he's been residing there for the past 4 years. His monthly portion of the rent is about $400 a month. Now, from what he advised me, there's really no one that can help post his monetary bond. As the state already did mention, he is out on a case, Judge, right now in which he's fighting. He has representation. He's been going to court. He's been meeting with his attorney. But, Judge, my understanding, like I said, on this case, is really financially, he's in a bind. So that's why we're going to be asking the court to consider releasing him ROR.
Mr. Linder, did you say that the case that he's out on bond? How much bond did he post?
1 moment, Judge. The total bond was originally $2,000. It was $1,000 for 2 counts. One of the counts was dropped, so it's a $1,000 bond now.
And Judge, my understanding, they're doing depositions. I believe they found Mr. Turner in a vehicle. There were drugs. There were other people in the vehicle. I believe there may have been statements made. That's what they're currently litigating at this point. So, Judge, like I said, he's been out, I believe, on 13 months. And now he's here, Judge.
All right, he is going to have a $2,500 bond on charge 1 and 4, and then the other standard bonds will remain in place, okay? Jorge Santiago.
Hello, Your Honor.
Good morning, Mr. Santiago. You're before the court for a grand theft charge, and I find probable cause.
Yes, sir.
Does Mr. Santiago have any prior state?
1 moment, Judge.
Mr. Santiago, this is the public defender. What you told me over the phone, is that something you want me to tell the court, or do you want to tell the court yourself?
Maybe, I think we could both share. Your Honor,
Hold on one second, okay?
I'm not showing anything, Judge.
Okay.
Judge, at this time, the court can hear from Mr. Santiago. I received a phone call from Mr. Santiago. We are concerned for Mr. Santiago. Since his apprehension, he has been wearing the same clothes since he came in. He has ulcerative colitis. He's bleeding in his rear. He's been sleeping and sitting in his own blood the whole time. He's asked for help since the moment he's entered the facility. He says all that's happened, not one doctor has seen him, nobody's helped. He says staff has laughed at him while he's had this stuff in his pants. So whatever happens in regards to the bond, he is also asking the court to enter an order that he sees medical immediately because he's not receiving the treatment from BSC.
So here's my question. Prior to making that statement today on the record, has there been any investigation into that matter? Did he contact his attorney?
This would be the first time he's speaking to an attorney since his arrest.
And all of that has happened in the last couple of hours?
You can ask, this is what he provided to me, Judge, yes.
Okay.
Your Honor,
Is the deputy, can I see the deputy on the screen, please? Deputy, you've heard what the attorney just said in regards to Mr. Santiago about bleeding and staff laughing at him. Are you aware of any of this information?
No, ma'am, I'm not.
And currently, he's standing right next to you. Is there any medical situation that you're observing that I can't see?
there is blood all
Sir,
over.
sir,
I'm sorry.
deputy, is there blood all over his clothes at this time?
No, ma'am.
All right. Do we need to sign, do we need to send him to, do I need to sign an order for an evaluation?
Judge, at this time, my understanding is if you put a request in through BSO,
Well,
trying to
wait,
see the
wait,
psych
Your
nurse
Honor.
or the medical nurse, that will be taken care of. I don't believe Mr. Turner, I'm sorry, Mr. Santiago has put a request in yet. Have you, sir, to see the doctor?
I
Other
have
than verbal?
requested. I'm sorry. I have requested to see the doctor to at least 15 officers. There is feces in my clothes right now, with blood. There's actually a blood stain on my shirt right now, so I don't understand how.
All right, deputy, have him step from behind the podium. Okay.
He's been housed in the medical infirmary.
All right, so I'm not seeing anything.
You would have.
Yes.
Your Honor, either way, the state has no objection when, during the request that he receive a medical screening, even if he's already received one, based upon.
I'll sign an order for a medical screening, okay? He has a $1,000 bond, okay?
Thank you.
Hector Chevalier,
Judge is here present, and me. Come on up, sir.
all right, Mr. Chevalier is before the court on one charge of burglary, unoccupied dwelling, unarmed. And I find probable cause. It's a cross-county line, so it's a first-degree felony. I find probable cause.
Judge, I expect there's probably more to this story than what's written on the PC affidavit. I haven't had an opportunity to review it, but my understanding, Judge, is I believe the location is where Mr. Chevalier was residing. He was residing there for the past 3 months with his girlfriend. My understanding is they had some sort of dispute, and he temporarily left the residence. My understanding is, speaking of Mr. Chevalier, this occurred at the residence when he came back, I believe, a couple days later. Now, he still advised me he still has belongings there, and I did advise him today's not his trial day, and that will be litigated out in a future court date. But there's a story behind what's probably written in the PC affidavit. Having said that, Judge, he's 47 years old. He's been residing in our community for the past 6 years. My understanding, he has no prior arrests. He just got a job, actually. He interviewed, I believe, last week on Friday, and he was supposed to be scheduled to start this week at a warehouse where he was going to make $12.75 an hour. My understanding from what he advised me, he has no one, unfortunately, contact to help post his monetary bond. So, Judge, I'm asking you to take that into consideration to determine reasonable release conditions for Mr. Chevalier.
All right, there may very well be more than what's in the probable cause affidavit, but what is in the probable cause affidavit is that at the time that the alleged victim was able to see Mr. Chevalier on her video on her phone in the home, she was at the courthouse obtaining a restraining order. And that he went and asked a neighbor for permission to go in the house, and that she told the neighbor that he did not have permission. And then shortly after, she sees him on her phone in the house. So,
Your Honor, I just also want to note, as far as Mr. Chevalier's knowledge about whether he could go in or not, apparently it says he was trespass warned. He acknowledged to law enforcement, the officer says that he was wearing a body-worn camera, that he knew he was trespass warned. So he knew that he had received a legal order, a lawful order, that he's not to be around that property.
all right. And does he have any priors?
I do not see any history.
Okay. All right, I am going to impose a $5,000 bond and no victim contact and no return to that location. Dennis, Lee Dennis.
Judge, Mr. Lee Dennis is a medical reset.
All right, thank you, Mr. Dennis. Is a medical reset. Corey Humphrey.
Mr. Humphrey, come on up, please. Judge, he's approaching. He's proceeding pro se.
Good morning, Mr. Humphrey. Sir, you understand that you are entitled to counsel for this hearing that we are in today?
Yes, I am.
And are you refusing the services of the Public Defender's Office at this time?
As a matter of fact, no, I will not. I can use a public defender now. Is that fine?
All right, I'll recall your case.
Recall?
Yes.
Thank you.
Christopher Brenham.
Is it with you, Judge?
Mr. Branham is before the court. Charge 1 is driving while license suspended, third or subsequent offense. Number 2 is possession of an open container, and I find probable cause.
One moment, Judge. Judge, actually, we're going to see if his bond's been posted.
Okay. It's not showing yet, Mr. Romero. He has a $750
Brendan's
bond.
going to post his bond. Thank
Okay.
you, Judge.
Jesty Latimer.
He's approaching. Judge, you hear me?
All right, Mr. Latimer, you are before the court. Charge 1 is possession of a controlled substance without prescription. Number 2 is resisting officer without violence. 3, 4, and 5 are leaving the scene of a crash involving damage to property. Number 6 is driving while license suspended, third or subsequent offense. And number 7 is careless driving. That's a traffic infraction. That's not for magistrate. And I find probable cause for these charges.
Judge, I'm going to be asking first for a photo order so we can photograph the injuries that Mr. Latimer sustained. And second, Judge, I'm going to be asking the court to sign a phone order so we can have access to his phone contacts to call his family to post a monetary bond.
All right, so I'll sign those photo and phone orders, and the standard bonds will remain in place. James Piscopas.
Mr. Piscopo, come on up here. Please approach the judge.
All right, sir, you are before the court this morning. Charge 1 is resisting officer with violence. Number 2 is panhandling. Number 3 is a violation of felony probation. Sir, that has a no bond hold that was issued by your judge. And you will see your judge tomorrow at 8:30 a.m. I find probable cause,
They would request a $500 bond on count one in lieu of the no bond hold.
and I'll impose a $500 bond on count one. Okay? Edric Civil,
Judge, can we have a photo order as well?
sure.
Mr. Romero, who'd you request that last photo order on?
Mr. Piscopo.
Thank you.
All right, Edric Civil is before the court. Charge one is possession with intent to sell, manufacture, or deliver cannabis. And number two is a traffic infraction that's not for magistrate. I find probable cause.
Judge, nothing to request at this time. I'm gonna be contacting his mother to post his monetary bond.
Does Mr. Civil have any priors?
Juveniles.
All right. Okay, so he has a $1,000 bond. Jalon Couch. All right, Mr. Couch, you're before the court. Charge one is grand theft auto. Number two is counterfeit credit card. Number three is possession of weapon or ammo by a convicted Florida felon. Number four is engage in criminal offense with a weapon. Yes.
It says subsequent offense. I don't see a prior. So at this point in time, I'm fine with the court finding no PC on count four.
All right, so no probable cause on four. I find probable cause on 1, 2, and 3.
Judge, I'm gonna be asking for a $1,000 bond on count three on Mr. Couch's behalf. Now, my understanding, he just recently relocated from northern Florida. Came down here to, his fiancee is pregnant. She's 6 months pregnant. He has family down here. He's specifically right now living with his cousin, where right now he's not paying rent. His cousin is helping him out while he gets on his feet. His cousin's a caretaker, and that's the only person that can maybe help post Mr. Couch's monetary bond. Now, he does have prior contact with the criminal justice system, but my understanding, Judge, he's been 3 years clean. So we're asking the court to consider a $1,000 bond on count three, Judge.
Your Honor, I'm going to be requesting a $5,000 bond on count three. First, based on these facts, it does seem like he should have been charged with carrying concealed firearm. It is cause, so we got a break on that as far as bond. It is cause for concern that he would unlawfully bring a firearm into a car rental office while allegedly trying to fraudulently obtain a vehicle. Fortunately, nothing happened with the firearm. As far as his criminal history, I'm showing out of Union County from 2011, grand theft, battery on a government official or employee, burglary of an occupied dwelling, trafficking stolen property, and grand theft out of Leon County in 2012, robbery by sudden snatching, 2 counts. On the Union County cases, he was sentenced to 4 years state prison, 2 years on the Leon County cases. He was released from state prison May 25th of 2017.
Right, so the allegations are that Mr. Couch is attempting to rent a vehicle from National Car Rental. He presented a Scotiabank credit card with a listed number, and that his name was on the card, but the card number comes back to a U.S. Bank National. He was also in possession of a driver's license that showed that his license has been suspended indefinitely. And then search incident to arrest, he has a chrome 25 caliber semi-automatic handgun, and he was detained at the car rental place. So based on those allegations, he has a $1,000 bond on 1, a $1,000 bond on 2. I am going to impose a $5,000 bond on 3. All right? And I found no probable cause for 4. Justin Sarmiento.
Judge, he's approaching and he declined to serve as a public defender. All right. All right, Mr. Humphrey, how long have you been?
Yes. On count 4, oh, yes. All right. Okay. All right, Mr. Sarmiento, you're before the court. Charge 1 is driving while license suspended, third or subsequent offense. Number 2 is operating vehicle unsafe. That's not for magistrate, it's a traffic infraction. 3, 4, 5, and 6 are traffic capuses, and those capuses were issued August 7th of this year for, on a charge of operating with a suspended driver's license. Then on September 16th, the judge issued a KPS for not showing up for court. Those charges are suspended driver's license, failure to register vehicle, unlawful tag or sticker. The judge did RORU on 2 and 3, but imposed a $500 bond on the suspended driver's license. You do have court tomorrow before your division judge. So I find probable cause. I am going to leave the bonds in place that were imposed by that judge, and you'll see the judge tomorrow, okay?
Can I post the bond today? Is that possible?
If you post the bond, you can post the bond, yes.
Thank you.
All right, Matthew Gizzy.
He's approaching, Judge.
All right, this is it on a bond surrender?
Yes, Your Honor, bond was originally set at $1,000.
All right, so, they've surrendered the bond, sir, and I'll reimpose the $1,000 bond that you originally had, okay? And this is on the charge of resisting officer with violence. All right, Danielle Gogota,
Conti, Your Honor,
all right?
he refused, and he said he knew he had a court date.
Okay, well, this is a serious allegations. It is a first-degree felony. It is a change of charge?
Well, yes,
Oh, that's, all right, there is a capias.
it's an upfile change of charge, Your Honor, and he was actually arraigned yesterday by Judge Usan.
Oh, he was?
Yes.
Okay. Did they make any changes to?
I don't know that it was ever even addressed.
Addressed?
The bond.
So how much was it, 7,500?
It was set at 7,500 when he was lawfully entitled to a bond. It was a strong arm robbery, Your Honor.
Right.
He also,
Well, why wouldn't they address that in court yesterday?
because even though I've mentioned this to the other ASAs, they might not even realize that he was being held no bond hold for magistrate at that point because of the change of charge.
All right.
He also has a no bond on an immigration.
All right, so based on the nature of the charge, I will reset Mr. Gogota for tomorrow, and then we'll see what happens with that. Because he needs to be here for that information. All right, Corey Humphrey, what were we doing with Mr. Humphrey?
I'm going to talk to Mr. Romero.
Oh,
I think he was on recall
okay.
for the public defender, yes.
Are you ready, Mr. Romero?
Yes, Judge.
All right. So, Mr. Humphreys, before the court, charge 1 is burglary, unoccupied dwelling, unarmed. Number 2 is resisting officer without violence. And number 3 is harming public servant or family. And I find probable cause. All right. So, I'll hear from the parties on regarding Mr. Humphrey.
Your Honor, I'm going to be requesting a $10,000 bond. This was a home, more specifically, this was his father's home that he allegedly broke into. Noting the strength of the evidence, he was witnessed by a neighbor breaking into the home. As far as history, he has a 2018 possession of substituted cathinones and refusal to supply DNA sample. placed on 6 months probation last October. He had a resisting without violence in 2017. And obviously, I'd be requesting no contact, no return.
Mr. Romero?
Judge, this is another one in which I believe there's probably more to the story than was probably written on the PC affidavit. And speaking with Mr. Humphrey, the residence is his father's. He actually goes back and forth and lives between his father's and his mother's home. My understanding, this is the first time he's ever been arrested in his life. He did acknowledge he was confronted by law enforcement when he was sitting outside his residence. My understanding is, Judge, there was an argument that ensued. At some point, Mr. Humphrey tried to take out, I believe, his identification, which shows the address on his identification as the same address that he's in front of.
All right, Mr. Romero, I know you haven't seen the probable cause affidavit. So, officers responded to a burglary in progress called in by a witness who saw the neighbor's son, Corey Humphrey, exit the residence via a rear window carrying a green duffel bag. Willis was also advised by another neighbor that she witnessed the defendant enter the home via the same rear window. Defendant then took off on foot. Responding units were provided. Bolo with physical description. They were unable to locate the defendant. On October 14th, officers patrolling the area of Corey Humphrey Sr. Residential Street when they saw the defendant, who was known to them and also matched the photograph provided by the victim at the time of the initial burglary, walk from the rear of 5970 Northwest 14th Place. He then sat on top of a gray Cadillac in the driveway of the target residence. Knowing Corey Humphrey Sr. desired prosecution for the initial burglary, I made contact with the defendant. It should be noted I'm wearing my uniform. Defendant immediately became argumentative and combative, and when I asked him what he was doing on his father's Cadillac in the driveway, he replied by saying, "I ain't got no father, and I am allowed to be here." They then asked him to identify himself. He took out his driver's license and then began screaming, expletives. You ain't got no right to talk to me. And while attempting to conduct my investigation, defendant ignored my commands to identify himself and told me he would punch me in the face if I touched him. As officers were attempting to detain defendant, he began bracing, pulling away while screaming, more expletives, and once officers were able to place defendant in handcuffs, his identity was verified by his Florida's driver's license. He kept saying he doesn't have a dad and he's dead to him. So I made contact with the dad, who said that he wished to pursue charges and did sign an affidavit of complaint. So those are the allegations that I have before me, and I find probable cause. I am going to impose a $5,000 bond, and if Mr. Humphrey posts his bond, he's going to be on pretrial supervision standard, no victim contact, and no return to that location. Okay. All right, folks, I believe this is the end of our docket, and I will see everyone at 1 p.m. Thank you.
Judge, could you sign a photo order on Mr. Humphrey's behalf?
Sure. I'm sorry? Yes, yes.